Good day, ma'am. This is my topic or my report about Customs Administration Order or CAO number 1 series of 2019. So topic, the most clearance audit and prior to disclosure program. In this topic, we're going to learn more on how to conduct post-clearance audit and considering the requirements to conduct the purpose and etc. Prior to disclosure program, on how to avail and who can avail the prior disclosure program. Authorities of the customs rules and regulations, penalties, taxes, and other charges. So, subject, post-clearance audit and prior to disclosure program. So, scope, the post-clearance audit, the prior disclosure program or PDP. Objectives, to be able to know what is the purpose of customs clearance, to be able to know the laws and regulations towards customs authorities, to be able to know what are the policies of PDP application and how we can avail with it, and to be able to know about the PCAG policies. So, we have definition of terms. So, first is custom. So, custom shall refers to any person who is bona fide holder of a valid certificate of registration. So, meaning, a customs broker is a licensed individual, whether for imported or exported through customs. So, next is customs clearance. So, customs clearance shall refer to a completion of customs and other government formalities necessary to allow goods to enter for a consumption, warehousing, transit of transshipment, or to be exported or placed under another customs procedure under the following customs regime. So meaning the customs clearance is necessary procedure before goods enter for a consumption. Example, if the shipment is cleared, then the shipper will provide a documentation confirming customs duties that are paid and that shipment can be processed. So, we have types of customs clearance. First is customs clearance for consumption. So, what is customs clearance consumption? So, customs clearance for consumption is before goods can be entered for a consumption, there is a procedure for final payment of duties, taxes, and other charges. So, number 2, customs clearance for warehousing. So, the customs clearance for warehousing entry shall refer to a procedure of filing of goods, declaration and duties, and taxes has been secured to be paid at the point of entry and legal permit for withdrawal has been granted. So, customs clearance for warehousing entry means a filing of goods declaration and the duties and taxes has been secured to be paid before goods can enter for a warehousing. So, number 3, customs clearance for transshipment. Customs clearance for transshipment shall refer to a customs procedure under which goods are given permit to be transferred under customs control for importing means of transport. So, customs clearance for transshipment meaning that this is the time which goods transferred under customs control from the importing means of transport within the area of customs or to one customs office. Next is customs clearance for transit entries. So, customs clearance for transit entries shall refer to a customs procedure under which good it is original for are given permit to be transported under customs control from one customs to another. So, meaning the customs clearance for transit entries procedure which good is given a permit to be transported under customs control from one another or to free zone. So next is fraud. So what is fraud? A fraud shall refers to a commission or omission of any act resulting in any material false statement, such as but not limited to the submission or false or altered documents in connection with any importation duties paid or to be avoid compliance with the government regulations related to entry, regulated, prohibited, or restricted goods into the Philippines territory through misdeclaration, misclassification, or undervaluation. So fraud means the falsification of documents submitted. So example, the falsification of statement. And another example is the skimming. Next is free zone. So what is free zone? So free zone shall refer to a special economic zone registered with Philippine Economic Zone Authority or PIZA under Republic Act number 7916 as amendment duly chartered or legislated special economic zone or John Hay Special Economic Zone and Subic Bay Freeport Zone under Republic Act number 7227 as amendment by Republic Act number 9400. The Aurora Special Economic Zone under Republic Act number 9490 as amended the Cagayan Special Economic Zone and Freeport under Republic Act number 7922, the Zamboanga City Special Economic Zone under Republic Act number 7903, the Freeport area of Bataan under Republic Act number 7903, the Freeport area of Bataan under Republic Act 9728, and such other free ports as established or mainly created by law. Free zone means that an area which good may be received and stored without payment of duty. That is, we called free zone. Next is importer. So importer shall refers to a person that buy goods from another country and bring it to their own country. So example, if I buy some goods and goods to Japan and bring here it in Philippines, so that is importer. Next is inadvertent. Inadvertent. What does inadvertent mean? So inadvertent error shall refer to a mechanical, electronical, or clerical error committed by an intentionally importer and occurred notwithstanding the maintenance of a material controls necessary to avoid such error. So inadvertent means that unintentionally or careless failure by the importer. So next is the locator. So what does the locator mean? So a locator shall refers to a person authorized to bring imported goods into free zone, such as the special economic zone and the free port. So locators means a person to be authorized to bring good into a free zone or free ports. Next is misclassification. What does the misclassification mean? Misclassification refers to the use of insufficient or wrong description of the goods, of the use or erroneous tariff headings resulting in deficiency between the duty and tax that should have been paid and duty and tax actually been paid. So misclassification means misclassification of description of goods. So example, instead of canned goods, they classified it into fabric. So that is misclassification. The misclassification of the description of goods. Next is the misdeclaration. So misdeclaration shall refer to a false or untruthful, erroneous, or inaccurate declaration as quantity, quality, or measurement weight of the goods. So the misdeclaration means is misdeclaration. So example of this is the misdeclaration of number of goods or the quantity of goods. From the goods declaration, the number of the imported goods is different to the final examination or physical examination of that goods. So misdeclaration. Next is negligence. Negligence. Negligence shall refer to a failure exercise reasonable care and competence through acts or acts of omission or commission. So the negligence is the failure to follow a bending ruling or a lack of reasonable care. So if it is so happen, there is penalty for this that we can read in section 592. Next is the principal place of business. So, principal place of business refers to the headquarters that hold the senior executive of a firm and is usually the center from another location and control. So, meaning the main office of the business. So, that is the principal place of business. So, next is post-clearance audit group. So, post-clearance audit group, what does it mean? Wait lang po. Post-clearance audit group shall refer to an office created under Executive Order number 160, series of 2003, as amendment by Executive Order number 46, series of 2017, mandated to conduct audit of importers, locators, and all parties engaged in customs clearance and processing. So the post-clearance is, the main purpose of this audit group is to conduct proper investigation on a post-clearance group. So the purpose of clearance group is to conduct the proper investigation or examination of audit findings. So what does reconsideration mean? Reconsideration of audit findings shall refer to a plea for the re-evaluation of the audit findings on the basis of existing records without need of additional evidence. It may be involved both a question of fact or a law of both. So meaning reconsideration is an importer can appeal for a re-evaluation without prior or without any evidence. Next is reinvestigation of audit findings. So, shall refer to a plea for the re-evaluation of the audit findings on the basis of newly discovered or additional evidence intended to be presented in reinvestigation. It may be also involve a question to be presented in the reinvestigation. It may also for the fact or of law of both. So reinvestigation mean that the importer can appeal for a reinvestigation together with the supporting documents and to be presented during the reinvestigation. Section 4 requirements to begin audit and examination of records. Within 3 years from the date of final payment of duties and taxes or customs clearance, as the case may be, the Bureau may conduct an audit examination. So it is very important that your goods or imported goods need to be kept because after or within 3 years from the date of final payment of duties and taxes, the Bureau may conduct an audit examination. So it is very important to keep all of those records from transactions or any activities. So entities required to maintain and keep records. So who are this person need or required to keep records? So first is the importer. Importer, all of those importers, including those mentioned in the importers definition. Next is the customs clearance and parties. Customs broker and other parties, all customs broker and other parties engaged in customs clearance and processing are required to keep a manual record or copies receiving from the transaction. Next is the locators. Locators also required to keep the records for transactions. Next is period of place where to keep records. So importer, as defined herein and in section 1003 in CMTA, are required to keep all records pertaining to ordinary course of human and to any activity or information contained in the word required by the CAO and by the CMTA at their principal place of business or period of 3 years from the final payment of duties and taxes or of customs clearance, whichever is the case may be. So, period place to be kept, so all importers are required to keep all records pertaining to the ordinary. So, it is necessary to keep the records pertaining to the ordinary course of business. Records required to be kept. So, here are the records required to be kept. So, number 1, this is the example of those records. Articles of incorporation, articles of partnership, registration of certificate with Department of Trade Industry. So, next is list of incorporators. So, list of incorporators, who are those incorporators, stockholders, partners, board of directors, and owners. So, next is the documentation on order and purchases, which includes, so example is sales and other agreements. Next is documentation on shipping, importation, exportation, and transport. So, the example of list of documentation that are required to keep is example of this is the goods declaration and proof of payment duties. That is the example. So next, section 5, post-clearance audit. So what is the post-clearance audit? So composition of post-clearance audit group is headed by assistant commissioners. So the post-clearance audit group is headed by the commissioner. So the following operating units. So there are following operating units: Trade Information and Risk Analysis Office, B, Compliance Assessment Office. So these two, each of them is headed by the director. So the purpose of this audit group is to investigate, do an examination, inspection, verification, investigation for all records and data within 3 years from the final payment of duties and taxes. Authority of the Commissioner to recognize post-clearance audit group. So the Commissioner, with the approval of the Secretary of Finance, is hereby authorized to determine the number of personnel requirements of the PCAG and issue necessary order to reassign the required organic personnel of the BOC to the group. So the Commissioner is authorized, with the approval of Secretary of Finance, to determine the number of personnel who will be reassigned into the Bureau of Customs, from the Bureau of Customs to reassign to the group of post-clearance audit group. So next is the function of post-clearance audit group. So the post-clearance audit group is mandated to conduct within 3 years from the date of final payment of duties and taxes or customs clearance an audit examination. So they conduct an audit examination, inspections, verifications, and investigation of records pertaining to any goods declaration which shall generated or machine readable data for the purpose of ascertaining the correctness of the goods declaration, and determining the liability of the importers for the duties, taxes, and other charges, including any fine or penalty. So next is conduct of post-clearance audit. So the post-clearance audit shall prepare a set of post-clearance audit procedures. So before they are going to conduct a post-clearance audit, make sure that they prepare for set of post-clearance audit procedures. So here are the procedure in conducting a post-clearance audit. So first is the profiling information analysis. So the profiling information analysis shall refer to perform risk profiling analysis activities on the importers. This includes data gathering and evaluation of import and export operations. So, profiling means this should be gathering data and information about the importer. So, that is profiling, gathered information about the importer. The most important about importer from the names and the background, so like that. Next is audit notification. The audit notification shall issue an audit notification. So the commissioner shall issue an audit notification letter or ANL to the company identified for audit. So, for those company who is identified for audit shall receive an audit notification letter coming from the commissioner. So, this is valid for 30 days and another 30 days for revalidation. If ANL is failure to serve the liability for this is those personnel in charge. So those are the audit notification or ANL. Next is the audit plan. So audit plan, the team shall prepare an audit plan to fit the circumstances of the audited company and meet the specific audit objectives in the most expeditious and transparent manner. So, before they conduct a proper audit, there should be a preparation for audit plan. So, that is the audit plan. The conduct of audit proper. So, the audit team shall commence the audit proper, not later than 60 calendar days from the service of ANL. So, after issuing the audit notification letter, so the audit team shall conduct a proper audit proper. In case the importer manifests his intention to valid avail of the PDP, the conduct of audit proper shall be deferred subject to provision of section 6.1.2. So, conduct of audit proper. So, this is conducted not later than 60 calendar days for the verification. The submission of document is required to be presented. So, the audit are fully complete within 120 calendar days per year. That is conduct of audit proper. It should be 60 calendar days before complete or 120 calendar days per year. So next is the service of demand letter for payment of deficiency. So within 5 calendar days from the receipt of the demand letter signed by the commissioner, the PCAG shall send the same to the importer through any of the following mode of service: by personal service at the principal place of business, by registered mail, or through electronic notice sent to the registered official electronic mail address with the demand to pay not later than 15 calendar days from the receipt. So the demand letter was signed by the commissioner. So within 5 calendar days from the receipt of demand, the letter signed by the commissioner, but with the following mode of service. First is the by personal service or by registered mail, And lastly, through the electronic mail address with a demand to pay not later than 15 calendar days. So next is the reconsideration or reinvestigation of an audit findings. The importer adversely affected by the deficiency assessment issued by the post-clearance audit group and approved by the commissioner may file a request for reconsideration or reinvestigation to the commissioner within 15 days from the receipt of the demand letter. For request for investigation, the importer shall submit all relevant documents in support therein within 30 days from the date of filing. Otherwise, the request shall be denied. The Bureau, through the Post-Clearance Audit Group, shall have 60 calendar days from the submission of complete documents to resolve the request. So, if the importer is failure to send all the documents or submit all the documents, the request shall be denied. Or an audit board. If the importer is not satisfied with the result of the audit findings, the importer can request a request for a reinvestigation to a commissioner within 15 days from the receipt of demands. So next is the acknowledgement letter. Acknowledgement letter upon payment of the duties amount demanded by the Bureau shall immediately issued without the need of request from the importers. So the acknowledgement letter is the without the request of importer, the acknowledgement letter issued by the commissioner. So without any request coming from the importer. Lastly, reporting to DOF and BIR. So the Bureau shall furnish the DOF and the BIR a copy of the final audit's result within 30 calendar days from the issuance thereof, including the amount paid by the importer. So, the Bureau shall report all the copies together with the payment of the importer. Next is the commissioner. Power of commissioner to obtain information, issue a summon. For the effective implementation of the post-clearance audit function of the Bureau, the commissioner is hereby authorized to obtain on a regular basis from any person, in addition to person who is subject of a post-clearance audit or investigation, or from any office or officer of the national and local governments, agency and instrumentalities, including the BSP and GOCCs, any information such as cost and volume of production, receipt or sales, and gross income of taxpayer, and the names, addresses, and financial statement of corporation. So meaning the commissioner has a power or right to issue a summon for those person who is engaged in such investigation. So next is summon the liable for duties and taxes or required to file goods declaration. Those person who is liable for duties and taxes are obtained for such summon issue. The commissioner issued a summon for those person who is liable for duties and taxes. Next is, so we have section number 6, prior to disclosure program. Who may avail of the prior disclosure program? So any importer without waiting for issuance of ANL can avail for the PDP or prior disclosure program. Or any person or importer who has received an ANL with the still avail the PDP, but by submitting the duly accomplished application form prescribed by the Bureau. Next is exclusive from the PDP. Who are those persons who shall not allowed to apply for the PDP? Goods declaration which are the subject of pending cases. Those goods declaration with pending cases in such court. Next, goods declaration which are covered by cases already filed and pending in court. So those goods declaration which are covered by cases already filed in pending courts are not allowed to apply for the PDP. Lastly, goods declaration involving fraud as defined under section 10.3.2 of this order. Verification and action on the application of PDP. So we have verification. The post-clearance audit shall verify the completeness of the PDP application form, including payment made and other supporting documents. Failure to comply with the necessary document shall result in the non-acceptance. If failure to complete those documents, there is non-acceptance or disposal of the application. So make sure that if you apply for the PDP, your application is complete. The audit team shall then verify the accuracy of deficiency duties in tax computation and determine if all errors are fully disclosed. The verification and approval or denial of the PDP application shall be completed within period of 90 calendar days from the submission of the complete PDP documents. So next, section 7, the interest on deficiency duties, taxes, and other charges plus fine and penalties. So this is the duties, taxes, and penalties. An interest of 20% per annum counted from the date of final assessment, as provided under Section 429 of CMTA, shall be imposed on prior to disclosure program availment. Deficiency, duties, taxes, and other charges, and fine or penalty if any. Section number 8, remedies of the importer. So what is the remedies of importer? When the request for reconsideration or reinvestigation is denied by the commissioner as provided in Section 5.5.1, letter F, in the whole or in a part, the importer may appeal such denial to the Court of Tax Appeals or CTA within 30 days from the receipt of the adverse ruling or decision of the commissioner. So meaning, if the request is denied, the importer may appeal a denial to the court. Section number 9, remedies of the Bureau. The remedies of the Bureau for the collection of import duties, taxes, fees, or charges resulting from the conduct of a post-clearance audit shall be obtained. Letter A, 9.9, 9.1, distraint of goods. So, distraint of goods, example is there is a seizure if someone's property like furniture or house belongings, bank accounts, and the interest in the rights to personal property. So, example of this personal property is the house belongings. Next, levy or levy upon real property and interest in such to real property. So, all of those the authority may collect those real property. The importer may receive an authenticated certificate together with the amount of tax and penalty. Civil criminal action. Any, all, or all of these remedies may be pursued at the discretion of the Bureau, provided that the remedies of distraint and levy shall not be allowed with the amount of duties and taxes including interest and penalties involved, is not more than 10,000 pesos. The Bureau shall advance the amount needed to defray cost of collection by means of civil or criminal action, which shall be included in the budget of the office of the Commissioner, including the preservation or transportation of personal property destroyed and the advertisement and sale thereof, as well as of real property and improvements. So meaning criminal action medium of trial and punishment. So the proceeding by which party charged with a public offense is accused and brought to the trial and trial punishment. So a criminal action or the action civil is brought by private party who has been injured or whose property has been damaged by some actions. But the district levy or levy is not allowed if the amount is not more than 10,000 pesos. Section 10, the administrative and criminal offense. So, failure to keep records. The following penalties. So, here are the following penalties if there is a failure to keep records. So, suspension or cancellation of accreditation as importer or broker with the Bureau. So, your accreditation as an importer or exporter may be suspended with the Bureau. The suspension or cancellation of the accreditation as importer. Surcharge of 20%. Surcharge or additional 20% on the dutiable value of the goods, which is subject of the importation for no records were kept maintained. If there is the no records to keep or maintained to keep, there is a 20% surcharge on the dutiable value. So next is hold delivery or release of subsequent imported articles to answer for the fine and any revised assessment. If your delivery is held, meaning to say you need to pay all of duties and taxes that you have never paid. Next is criminal prosecution punishable. So there is a criminal prosecution punishable if you have failure to keep or maintain to keep your records with imprisonment or not less than 3 years and 1 day but not more than 6 years and or fine of 1 million pesos. Waiver of the right to contest the result of the audit base or record to keep by the Bureau. So next is the failure or refusal to give full and free access. So the following penalties are impossible to those who deny the authorized customs officer. Full and free access to records required to be kept by maintained. Punishment or contempt for contumacy or refusal to provide access from the proper court having criminal jurisdiction over the matter, or suspension or cancellation of accreditation as an importer or broker with the Bureau. So your accreditation as an importer or broker may be suspended. And plus 20% of dutiable value to the goods which is subject of importation for which no record were kept and maintained. And another criminal prosecution punishment with imprisonment or not less than 3 years and 1 day but not more than 6 years and for fine of 1 million pesos. Next is failure to pay correct duties and taxes on imported goods. So any person who failed to pay the correct duties and taxes on imported goods are subject to the penalty. So these are the penalties. Negligence. When a deficiency or when you are guilty for the negligence and found guilty shall be penalized with fine equivalent to 25% of the revenue loss. So if you found guilty with that negligence and if you found guilty you are penalized with a fine equivalent to 125%. Next is fraud. Fraud and is found guilty thereof shall be penalized such fine equivalent to 6 times of the revenue loss and or imprisonment of not less than 2 years and but not more than 8 years. Next, Section 11, records to be kept by the Bureau. So, these are the records need to be kept by the Bureau. Articles of incorporation. So, what are those articles of incorporations? The company structure, which shall include but not limited to incorporators and board of directors. So, incorporator is the person or those person who manage the corporation. So, that is incorporator and board of directors. K officer. So, example of the K officer is the corporate officer. Organizational structure. K importers or importation village Illinois. Record of violation and penalties. So, records for the record of violation and penalties are records to be kept by the Bureau. So, infringement committed. So, example of this is unauthorized violation, use or the copyright. Instances of smuggling. Instances of technical smuggling. So, the misdeclaration of the classification of goods. And undervaluation. Risk categories like strategic, financial, operational, people, inventory, and finance. Section 12. Next is Section 12. Audit, monitoring, and record keeping. So, all records shall establish and maintain a real-time case monitoring and control system to ensure that all tasks related to the audit operation are completed. So, all records need to be kept because the real-time monitoring with the purpose is to maintain the record keeping or database and records. Section 13. Review periodic. Unless otherwise provided, this order shall be reviewed every 3 years and amendment or revised as necessary. So, every 3 years, there is a review of periodic. Turnover of records. So, the Bureau may turn over the records into DOF or AIAO or Fiscal Intelligence Unit. Shall turn over all files and documents including any pending post-clearance audit to the BOC or PCAG. So, Section 15, repealing clause. Section 15 is the repealing clause or the resolution. So, in this section, there is a resolution happen. Section 16 is the separability clause. If any part of this order is declared unconstitutionally or contrary to existing law, the other part are not so declared shall remain in full force effect. So, if there is a separability clause, if the order is declared unconstitutional, so there is the other part is not so declared and shall remain into full force. Next is effectivity. So, the effective of those this order shall take effect 30 calendar days after its publication on the Official Gazette or a newspaper of national circulation. The Office of the National Administrative Register or owner of the law center shall be provided 3-year certificate copies of their orders. So, that is Section 17, the effectivity. So, within the effect shall be take effect 30 calendar days after its publication. And the Office of National Administrative Register or owner shall be provided 3 certified copies of this order. So here are the summary of my report.
Customs broker, a bona fide holder of a certificate of registration. Customs clearance shall refer to a completion of customs and other government formalities necessary to allow goods to enter for a consumption. Fraud shall refer to commission or omission of any act resulting in any material false statement. Free zone refers to an economic zone. Importer, a person who buy goods from another country to bring on our own country. Inadvertent error shall refer to a mechanical, electronical, or clerical error submitted by an intentionally importer and occurred notwithstanding the maintenance of internal controls necessary to avoid such errors. Locator shall refer to a person authorized to bring imported goods into free zone. Misclassification shall refer to the use of insufficient or wrong description of the goods. Misdeclaration shall refer to false, untruthful, erroneous, or inaccurate declaration as such quality, description, weight, or measurement. Negligence shall refer to a failure to exercise a reasonable care or competence. Principal place of business shall refer to headquarters that hold senior executive of firms and is usually centered from where other locations are controlled. Lastly, prior to disclosure program shall refer to a program based on internal best customs practice authorizing the commissioner of the customs to be accepted.
That's all. Thank you, ma'am. Sorry